Jefferson County Court at Law number 2 is now in session. The court is in session and calls number M331098. The case is styled State of Texas versus Kevin Andrews. Ms. Andrews, is that your full name? Yes, sir. Ms. Andrews, would you please raise your right hand?
I think her full name is Heaven Lee Andrews.
Heaven Lee Andrews.
L-E-I-G-A.
Okay. Ms. Andrews, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth so help you God? Sure. You may put your hand down. How are you doing, Ms. Andrews?
I'm doing better.
Okay. Now, Ms. Andrews, you're here represented by your attorney, Attorney Wright Kimler. Attorney Kimler, how are you doing?
Fine, Your Honor, thanks.
Mr. Kimler, I have, the state is also represented in this case by Attorney Colby Hallfire. Attorney Hallfire, how are you doing?
Good, Your Honor, thank you.
Now, Mr. Kimler, I have before me the first amended motion to revoke the unadjudicated probation. I also have before me an agreed stipulation of evidence.
The state's elected to proceed on count 4, Your Honor, which the stipulation of evidence pertains to.
Yes, yes. Now, Ms. Andrews,
The state's gonna, just for the record, we're gonna abandon allegations 1, 2, 3, 5, 6, 7, and 8.
okay,
Proceed only on 4.
okay. Now, Ms. Andrews, I have before me first amended motion to revoke unadjudicated probation. That was filed by the Jefferson County District Attorney's Office. This motion alleges that you, Kevin Andrews, is a defendant in this case, was tried in this court, County Court at Law number 2 of Jefferson County, Texas, on March 14th of 2022 for the Class A misdemeanor offense of possession of controlled substance. The court found that the evidence was sufficient beyond a reasonable doubt to support a finding of guilt for the offense of possession of controlled substance penalty Class A misdemeanor, and the court placed you on unadjudicated probation for a period of 2 years. In this motion, there are 8 allegations. However, the state is abandoning allegations 1, 2, 3, 5, 6, 7, and 8. And what that means is the state will only be proceeding on allegation number 4. Now, in allegation number 4, it states that you, Heaven Andrews, failed to perform community service hours as required by the court in violation of condition 14 of your probation order. Is that true or not true?
It's true.
True, okay. Now, now you're pleading true freely and voluntarily?
It's not true.
And are you pleading true because it is true?
It's not.
All right. Now, Ms. Andrews, also,
Your Honor, just for the record, I think she's previously pled true to count 4 on October 28th of 2022.
yes,
That's correct, Your Honor.
yes, she did. And Ms. Andrews, I also have a copy of that, the motion to revoke, and it has here my initials, and it has the plea of true, and it also has the date of October 28, 2022, when you originally pled true, and the court had reset this case for an adjusted or a pre-sentence investigation report. Now, before we get to that, I have before me a misdemeanor plea admonishments. Do you recognize this document? You do? On page 2 of this document, there's a set of initials on a line. The initials are HA, and they're on the line next to a box that's checked MTRP true to allegation 4. Did you place your initials on this document? On page 3 of this same document, there is a signature above the line that's titled defendant. Is that your signature? Also, on the next document that's titled Trial Court Certification of Defendant's Right of Appeal, Do you recognize this document? And is this your signature? Yeah, is this your signature on the line that's titled defendant?
Is there any?
Okay. Now, there's one box that's checked, that's, and the box that's checked said that this is not a plea bargain case, and the defendant has the right to an appeal. Do you understand that? Do you understand that?
You have the right to appeal, you understand?
What is guilty?
You can go up to the higher court and ask them to look and see if there are any mistakes that were made here. You're not giving it. Okay, you're not waiving.
Okay, now, Ms. Andrews, before you signed and initialed all of these documents that I have just mentioned to you, did your attorney go over these documents with you?
Very good.
And did you read and understand everything he went over? And is everything in these documents true and correct to the best of your knowledge?
Yes,
Okay. Now, Ms. Andrews, Ms. Andrews, are you a citizen of the United States?
yes, sir.
State, I have before me State's Exhibit number 1. State, would you like to offer State's Exhibit number 1?
We would, Your Honor.
Any objections?
Without objection.
No objection. State's Exhibit number 1 will be admitted. Mr. Kimley, you advised in counsel, Ms. Andrews, is there any evidence that she is currently mentally incompetent to stand trial?
No, Your Honor.
And Ms. Andrews, your attorney, Mr. Kimley, has advised and counseled you. Are you satisfied with his representation? Has he provided full, effective, and competent legal representation? Ms. Andrews, I will accept your plea of true. I will find of your plea of true to allegation number 4. I will find that your plea and waivers was freely and voluntarily given. I also find that there is sufficient evidence to revoke your unadjudicated probation, and your unadjudicated probation is hereby revoked. And the court will also take judicial notice of the court's file. State, do we have a plea bargain agreement?
We don't, Your Honor. We're gonna leave that up to the court. We'd ask that at the proper time to proceed to punishment.
Okay,
And
okay, now, at this time, we will have argument. Mr. Kimler?
Your Honor, I've reviewed the adjustment to probation memorandum that was filed with the court today on November 22nd of 2022. I really don't know why it's taken, this long to get before the court for sentencing. I'm not, casting any blame, but I think it's kind of unusual. It's 6 months after we get the update that we're proceeding to sentencing. I think during this time period, Bill did report to probation. She was under the understanding that she didn't have to or need to. So be that, let me finish. You can talk. It's your turn. All right. But it was her understanding she wasn't required to based upon discussions she'd had with her then probation officer. I don't know, as far as the veracity of that, but in any case, I don't believe there's been any contact between Ms. Andrews and the probation department from November, or actually October of 2022 to the present. My observation is that obviously there's a lot of things in the pre-sentence in the motion to revoke probation that are adverse to Ms. Andrews if the state had proved them or if she pled true to them, specifically these new felony offenses in Chambers County. However, the state of the evidence at this point is that she's only pled true to not doing her community service. That's the only allegation before the court that there's evidence or any kind of confirmation that it's true. Thus, the recommendation contained in the pre-sentence report of maximum jail time, I think, is without foundation, and that the new cases haven't been proved up. And what the court is dealing with is simply a defendant that hasn't completed her community service. Being as such, I would suggest to the court that a jail time sentence would be appropriate in this case. We're asking the court to assess 15 days county jail.
Okay, Mr. Hopper?
And the state, and my understanding, Judge, and obviously I wasn't on this case in October back when there was the original plea of truth.
Right.
Another thing, and I don't argue with counsel about what we're proceeding on. There's not an argument in there. I do think that there's a reason why that this wasn't done until this time. I believe it was because the defendant didn't show the court a couple of times.
Right.
Therefore, it wasn't fault of probation, which she still should have been reported. She never got, instructions to do that. She was still on probation until she was sent punishment. So she was already under that instruction. Whether or not they keep giving it to her is irrelevant. And I think that in regards to this particular case, and we didn't enter it into evidence, but the court and the state wished to test the defendant in this case, and she tested positive for multiple controlled substances, Your Honor, on this date, May 31st, 2023. And that's part of, as being on probation, not to take that, unless she tested positive. I'm in agreement with counsel about the maximum jail time. That would be a year in jail. That's not saying, not asking for 365 days in jail. However, we're not asking for a minimum jail time either. I think it needs to be commensurate with what she's shown as not, doing her probation and still using narcotics while she's on probation, which she is today. She's still on it. So state's asking for 90 days in jail.
Okay,
She wanted to address the court. Okay, you
Okay.
can talk to the judge.
I'm sorry. I have not followed the rules of probation. I did fill out my report just last month, and she was like, you don't have to do that anymore, but well, go ahead and report it. I have had a vehicle, my vehicle got stolen from me. That is also been reported to Galveston County. I don't have a job. I don't have a way around. I don't have these. I do struggle with the use of drugs. I do, but I just had a daughter. And I don't want to lose her. I can go without doing drugs. I can do it the right way this time. I can. I don't deserve another chance. I don't. I don't know really what else to say. I mean, I don't deserve any money to feel bad for me. I really don't. Is there any way I can do the patch? I mean, or something. I know that yes, I have filled for drugs and amphetamine, but I haven't been doing any other than that. It's stupid, I haven't been doing breaking and entering. I haven't been just acting crazy. It's just a struggle.
what type of drugs did she test positive for?
Methamphetamine and marijuana, and amphetamine, methamphetamine.
And there shouldn't be amphetamine because I haven't done anything.
It's a
The
metabolite.
metabolite, just the methamphetamine and the THC.
Okay,
I promise I will. I promise.
oh,
My parents are old. Dad.
now, let me ask you, see, what is her criminal history?
As far as,
Does she have any
I
priors?
believe, Your Honor, if the full PSI which was done, it's included. You took judicial notice of the court's file
Okay,
without just the update of the original PSI. But I will give the court a summary of it.
well, and before we do that, pursuant to Article 1.24 of the Texas Code of Criminal Procedure, all trials and proceedings shall be public. However, pursuant to Lilly versus State, 365 Southwest 3rd, 321, the right to public trial is not absolute and may be outweighed by other competing interests such as the non-disclosure of public information, interests, well, not only the non-disclosure of public information, but also that the defendant receives a fair trial. In this case, the defendant's criminal history is not public information, and so that information will be disclosed. So, Mr. Kimler, are you requesting that this portion of the hearing be closed to
Yes, Your Honor.
prevent the non-disclosure of public information, so that the court finds that the party seeking the hearing to be closed have an advanced and overriding interest that is likely to be prejudiced to the defendant if they will disclose the non-disclosure of public information. It The court also finds that the closure is no broader than necessary to protect the defendant's interest, and the trial court have considered other reasonable alternatives to closing this proceeding. And the court make these findings, and the court believes that these findings are adequate to protect the interests of the defendant. And so at this time, this portion of the hearing will be closed pursuant to Liddy versus State 365 Southwest 3rd, 321, to prevent the disclosure of non-public information.